Thank you. Thank you for being here. We're here in our case 1CA. It's a consolidated case 1CA MH 15-0107 and MH 16-0021 entitled MH 2015-002490. Each side will have 20 minutes to present their argument. Appellant, you may save any time that you want for rebuttal, but you're responsible for keeping track of that yourself. We have a clock at the podium for that purpose. We are recording the argument. It will come up on YouTube in 2 or 3 days. Because we're recording it, please identify your client and yourself when you begin your argument so we can keep everything straight. We've read the briefs, we've examined the record, we've conferenced the case, so we're familiar with the issues. So when you begin your argument, begin with what you would like for us to know. Counsel, you may begin.
May it please the Court. My name is Aubrey Joy Corcoran, and I represent the Arizona Department of Health Services, which maintains the Arizona State Hospital. I would like to try to reserve 5 minutes for rebuttal.
Well stated, counsel. Try.
I'd like to begin by making 3 points. First, the Superior Court incorrectly interpreted the U.S. Attorney General order when it stated that mental health treatment is generally exempt from Perora's eligibility verification requirements. The U.S. Attorney General order, which was supported by the Arizona Attorney General opinion, explicitly states that non-emergency mental health treatment is a public benefit and is not exempt from Perora's eligibility verification requirements unless there is an exception. Second, there is evidence in the record to demonstrate that the hospital does not meet all 3 prongs of the exemption test set forth in 8 U.S.C. section 1621b4. The Superior Court assumed facts not in evidence when it initially issued its ruling, and when it decided that the state hospital did in fact meet all 3 prongs of the exemption test. And then when presented with declarations establishing that the hospital did not meet the first 2 prongs of the test, it nonetheless maintained its ruling contrary to the evidence presented.
Counsel, so we don't know for sure whether the individuals involved in this case are not here legally. The basis is that they haven't proved that they're here legally?
Your Honor, there is no finding as to whether the individuals subject to this case are lawfully present. However,
is there a requirement that the court find them lawfully present before it involuntarily commit them to ASH?
The issue was that the problem with the court
Here's what
order.
I'm concerned about. I'm wanting to go to the law.
Yes.
I want you to tie us back early on to the law. Is there a requirement under law that would indicate, let's say, that the trial judge violated state law in not making a finding that they were lawfully present before having them voluntarily committed?
No, Your Honor. The problem was when the Superior Court was notified that its order conflicted with state and federal law and then did not resolve the issue of the conflict.
But didn't the court resolve the issue? Go ahead, I'm sorry.
No.
But didn't court resolve the issue? There's no law saying he's got to do this. There's law addressing the issue of involuntary commitment, but not that he has to find that they're lawfully present, and he did what he was required by law to do, didn't he?
There's no requirement under the civil commitment statutes to make a finding. However, there is a prohibition for the hospital to provide mental health services to individuals who cannot demonstrate their lawful presence in the United States.
Right, so that would get to my question, which is why isn't the correct procedural mechanism for this, for you all, representing the hospital, once you've made the determination that they don't fit within per ora, to then seek declaratory judgment or some type of action to say we can no longer provide this? Why are you putting it on the Superior Court at the initiation of this as opposed to once we actually know we have a problem?
I'm not certain I entirely understand the question. What happened was that the hospital is not a party to the initial commitment hearing, so they are not aware that there is a problem until there is the order to commit those individuals to the state hospital.
Said already, we don't have anything in our record to determine whether these people are actually even subject to per ora right now.
What we have in the record is the assertion.
Doubt. There's some doubt in the record, but you don't have a finding. You guys have not made a determination, nor have you asserted to the court that they are not lawfully present.
No, there's nothing in the record, and so that is why we are requesting remand, is for a finding as to whether or not these individuals can demonstrate their lawful presence in the United States.
You just told us the Superior Court is not obligated to make that finding before sending it to you. So my point is, and I'll try and rephrase the question because I'm obviously not asking it very well, and I apologize for that. Superior Court did what it was supposed to under Arizona law and under federal law, to the extent we have it, in saying these people are dangerous and they need to be civilly committed and voluntarily committed. Why isn't the obligation then on you, if you ultimately determine, oh my gosh, we can't treat these people because they're not lawfully present, to then file a petition, file some type of action to say we're no longer treating them, we want them released?
Well, that is what the hospital attempted to do here by filing its motion for reconsideration.
Did not make a finding. You tried to send it back to the court to make that finding.
The hospital sought from these individuals a documentation to demonstrate their lawful presence. When those individuals could not demonstrate their lawful presence, then the hospital realized that it would be unlawful to provide these individuals with the treatment that was ordered by the Superior Court. For that reason, the hospital went back to the Superior Court to inform it that its order to the state hospital was requiring it to provide services that it was not lawfully able to provide.
If it was unlawful, why didn't you just release them right then?
Because there is no determination to date by a court to establish the fact that the benefits provided by the state hospital are public benefits. It is our position that they are, but we also did not want to be in violation of a court order. So the hospital was put in a position where it could either violate a court order and have a court rule that the treatment provided by the state hospital is not a public benefit, and then it is in violation of court order. Or it could notify the court that it was being ordered to do something that it was not permitted to do.
Now I'm confused.
We're confusing each other.
You're in possession of a court order directing that they be involuntarily committed to ASH. With me so far? I mean, I'm serious. I want to take this very slowly. And you're saying, wait a minute, we can't put them into ASH because we think that their involuntary commitment to ASH would be a violation of per ora, correct?
Correct.
So we're going to hold them in jail in the meantime because you're not letting them go, right?
Well, there is
which would be a violation of per ora. That's a public benefit, it isn't? Because it's detention, they get a room, they get a place to sleep, they get food, all that stuff present, including medical issues for these people who have medical issues. So how can you say that there's a violation of per ora in them being held in the state hospital, but not in them being held in the lockup? Because
there's a difference between the criminal detention versus civil commitment.
No, but what he's saying is that after the criminal detention's done, you're still detaining them while this is going on. So how are you doing that?
How's one different than the other?
You are currently holding them.
We are currently, in good faith, honoring the Superior Court order while we are attempting to determine the issue of law in this court.
And I want to be clear. I don't think that you would hold them anywhere in bad faith. Okay? So I'm not meaning to assert that that's wrong. I'm saying, how does the one not constitute the same violation you're claiming to be the other?
And I guess my thought is I'm having a hard time thinking of involuntary commitment as a public benefit. Because because I guess that would mean that it is a benefit that if I am mentally ill and a danger to society, I have the right to be put in the hospital for my protection and the protection of others. That if that is a public benefit, then having the right to be incarcerated because I've potentially committed a crime is also a public benefit. And you say that, as I understand your argument, you say those are two different things, and I'm not seeing it.
They are two different things because mental health treatment is defined by the U.S. Attorney General as a public benefit. Incarceration is not. Additionally, the intent of...
What about the things that happen during incarceration? Food.
Those are incidental to the primary purpose of incarceration, which is retribution and to penalize the individual.
But the primary purpose is also to take people off the street, which the primary purpose of civil commitment is to get people off the street as well and protect them and the public at large.
The primary purpose of civil commitment is to treat the individuals, and that is actually set forth in ARS Section 36202, that the state hospital was established for the intent of treating individuals who can benefit from inpatient treatment. There was no intent.
But not as opposed to outpatient treatment, because these people represent a danger to themselves or the community, we're going to inpatient treat them as opposed to outpatient treatment.
Well, not necessarily. That is not the only reason why someone can be committed to the state hospital, is because they're a danger to self and others. They can also be committed to the state hospital if they are gravely disabled, for example. So the intent of the state hospital is, in fact, treatment. That is its primary purpose. The primary purpose is not to detain the individuals.
So Ash no longer maintains a security area for dangerous, psychotic patients?
It does maintain a security area.
Are these two people dangerous, psychotic patients?
One of them was determined to be a danger to others. In terms of their current placement at the state hospital and whether or not they are in that secure location, that information is not in the record, and I'm not able to speak to that.
So the involuntary commitment is really no different than a weekend at the, an exotic hotel, right? They're just getting medical treatment. All they're doing is resting up and getting medical treatment? Or are they being held there in order to protect the public from the propensities they have given their mental disabilities?
It depends on the reason for the commitment and the individual's, the benefit, how far they have progressed in the treatment that they have been provided at the state hospital.
And the judge in this case specifically found that the likelihood of them recovering from their mental illness, that changing was next to nothing, right?
Well, that could be a complete recovery. Whether or not there could be some mitigation of their mental impairment, that it remains possible.
So they are detained at the state mental hospital until they make that degree of recovery that allows them to be released, which may be never, correct?
Correct.
Okay, they're being detained at the state hospital. So now we're back to the corollary, I think, with the jails. How are the jails doing anything different than than the state hospital is in regard to these people, such that one's a public benefit? Going to jail is not a public benefit, but being locked up in similar fashion at the state hospital is.
It is because of the distinction between the purpose of criminal incarceration and mental health treatment. And the fact that someone is unable or unwilling to apply for mental health treatment on their own behalf does not change the nature of the benefits that are provided to that individual. So,
and Are you familiar with Rule 11 in federal rule or state rules of criminal procedure?
No, somewhat.
Okay. So in Rule 11, the state, and I presume the Attorney General's office frequently, seeks to have people restored to competency through mental health treatment in pretrial matters in order to allow the state to prosecute them. Is that correct?
Yes.
Okay. That is intended to restore to them competency. It is a treatment that you seek under Rule 11, and the Attorney General's office routinely seeks this during criminal prosecutions with people who have mental health issues. How is that different than this?
Because the intent there is to restore them to competency so that they can be prosecuted and then serve their time and serve that purpose of retribution and the penalties associated with that.
So if we just change the intent, but do exactly what we're doing now, we could call it a public benefit. Or we could say it wasn't a benefit. I mean, we could pretty much do what we wanted to do as long as we just reconfigure the purpose of the institution they're in. Is it simply the basis by which we operate the hospital and the jails that makes the difference, or is the fact that these people are being involuntarily detained?
I think what it is the type of service that is being provided and whether or not that has been determined to be a public benefit. And to do that, you also look to the intent of perora. So under 8 U.S.C. Section 1601, the intent of perora is to discourage illegal immigration, but also to not burden the public benefit system. That does not
apply for benefits. So 1601 specifically mentions people who are applying for benefits.
Correct.
And how are these individuals applying for benefits? It seems like they're being coerced into receiving them.
Well, the only reason that they are being involuntarily committed is because they are unwilling or unable to seek voluntary commitment. So, but for their inability to seek voluntary commitment, they would on their own seek that commitment. So the fact that someone is applying on their behalf...
I'm sorry, on what basis in the record can we make that finding? They would have sought this on their own, but for?
Well, there has to be in order for involuntary commitment to occur, there has to be a finding that the person is unwilling and unable to seek voluntary treatment.
Right, but that's not the same as, and they would have on their own if they had been willing.
Well, the corollary to that is that someone would seek voluntary treatment.
Would or could?
Could.
So is there evidence in the record that these individuals were asked if they wanted treatment and they said no?
That has to be a finding in order for there to be involuntary commitment, is that the individual is unwilling or unable to request treatment.
Part of that, isn't it, counsel?
I'm sorry, Your Honor?
Unable is a big part of that.
It is either unwilling or unable.
In fact, these people are not capable of being prosecuted because they're not able to assist in their own defense, right?
One of these individuals, that is correct. For Edgar T., that was not the situation when he was involuntarily committed. He was being removed from his outpatient treatment facility because he was undocumented and therefore ineligible for the services.
Are these the first two illegal aliens that have been sent to ASH since 1996?
That is not in the record, and I am unable to speak to that.
But this statute's been in place since 1996, and it's only within the last year that someone said, oops, we may have an issue here. So you guys may have been violating the law for the last 21 years, 22 years?
I believe that's a factual issue that I cannot speak to as to what...
Hypothesize with me.
It has been in place since 1996, and I am unaware of whether or not the hospital has admitted other individuals. Or let me put it this way. It is not in the record as to whether or not the hospital has admitted individuals, and therefore I'm not able to speak to that.
And clients, may I? I want to be real clear on something else you said. The only person we know to not be a legal citizen in this case is the Native American?
No, there has been no finding.
No finding that he's a Native American, or no finding Of what?
No finding as to whether or not they were able to demonstrate lawful presence, which was the requirement in order to receive mental health treatment at the state hospital. And, Your Honor, if I may reserve the remaining
Please.
portion of my time.
Of course
Thank
you
you.
may. Counsel?
Good afternoon. May it please the court. I am David Ouimet, my associate Vale Clore, Dickinson Wright Law Firm, on behalf of the intervener. I'll refer to it as the district. District representatives are here as well today. I'd like to start with addressing some of the questions that the court was asking about the exception, the series of 3 parts to an exception to the PROWARA eligibility requirements, which is what the Superior Court was talking about. And we're not here to defend that particular reasoning, but if the Superior Court got it right for any reason, it needs to be affirmed. And the reason we submit that the issue of the exception to PROWARA is a bit of a red herring is that you don't need to get to the exception unless you find that it applies in the first place. And PROWARA only applies if what we're talking about is a public benefit. And I know the court has gotten into that substantially, but I just wanted to put that in the context of at least the way we're looking at it, which is unless you get to the point of determining that this is a public benefit to be involuntarily incarcerated, committed, to the state hospital, you don't even need to address whether the exception applies.
Counsel, can you? Go ahead.
So, I'm sorry.
No.
Can benefits be foisted upon someone is to be deemed a public benefit?
We don't believe they can, and we believe that's supported not only by the letter of the law, but the stated purpose of PROWARA, which is in the statute. And it's pretty clear what the legislature had in mind, both the United States and the Arizona legislatures, when they passed these rather sweeping restrictions. What they're targeting is the problem of folks who are crossing the border in hopes of obtaining public benefits in the nature of food stamps, welfare, that sort of thing, and putting a burden on Arizona's economy. It's a real stretch, and we say it's a stretch too far to say, well, that should extend to somebody who's being involuntarily committed because he's so incompetent and incapable and so dangerous that he shouldn't be allowed to live at large in society, at least until he's...
Is it a benefit for the individual or a measure of protection for the community?
Well, it's both, and to the extent it's a measure of protection for the community, it's not a benefit to the individual. There are sort of at cross purposes here, and one of the cases that the hospital cited in its reply is a North Carolina case, which we submit doesn't apply for a number of reasons, but it includes an interesting discussion from the North Carolina Attorney General commenting that where the benefit component of a commitment is incidental to the protection of the public, then that doesn't fall within PROWARA, because we're talking about a public decision which is being made to protect the public. And the fact that as an incident to that, the individual gets some health care, gets housing, gets fed, that's incidental. It doesn't make it a benefit to him to be involuntarily committed any more than it's a benefit to a prisoner to be incarcerated, either in the jail or the prison system, even though they get publicly funded things like food, medical care, etc., as part of that. The central focus is the protection of the public, and both of these individuals were determined to have been a danger to others as the principal reason why they are in Ashe at this time. Had it not been for that finding, we wouldn't be here. The reason they're there is because of the finding of danger to others, and there's a little bit of a confusion in the record as to Mr. E.T. The initial order of commitment did not check the box for danger to others, but that was corrected later, and in fact, by the order that the state proposed that the court enter, which did include that finding. So both of these individuals have been found to be danger to others.
Counsel, can you help us clear up something that was originally stated? My full recollection of the record is that it clearly establishes that Edgar E.T., whatever you want to refer to him, is a Native American.
There are certainly references, and it is E.T., several references to the fact that he's Native American.
In fact, he gave 2 places in the United States, which apparently created the conundrum here as to how do we know he's not illegally in this country if he says that he's both from New Mexico and Colorado or something like that. So I'm lost on how we draw the presumption from the fact that he is a Native American to the fact that he's possibly in the country illegally. Do you know how that came about? Because that's kind of an anomaly to me.
There are passing references in the underlying documents, the police reports, the medical histories, that make comments about both of these individuals to the effect that, well, he may be undocumented, he may not be eligible for services, but as to both of them, there are conflicting pieces of information, most notably the Native American comments, that suggest, well, wait a minute, maybe this person is here legally, which leads to the question, if you assume an individual in the circumstances of these two, they're homeless, one of them's living out of a dumpster apparently, they're not able to communicate, how would they demonstrate lawful presence? It's not like they can pull out a wallet with a copy of their passport. And what is noticeably absent from the record is what exactly the hospital did to try to determine whether they were here lawfully or not.
And the determination was what?
What's that?
You said a determination, they attempted to make a determination? Or there was no record as to their attempt to make a determination?
There's nothing in the record as to how the hospital had attempted to determine whether these individuals were or were not here lawfully. In fact, the objections to the court's orders were filed before they were transferred to the hospital. But if it's a matter of sitting in a room with this individual who can't communicate and asking him, where are your documents, and he either says nothing or says something incomprehensible, how does that lead us to the point where we can say, well, he can't be treated?
So it's really not an issue for whether these individuals are actually unlawfully present or not. It's that they can't prove that they are lawfully present. And that's the statute requires proof, and that's what we're dealing with here.
The Arizona statute purports to require a list of documents which are acceptable. The federal statute doesn't say anything about that. The federal statute just talks about someone unlawfully present. So we've got a major distinction there, and we didn't get into it in the briefing here, but if it got to the point where Arizona was imposing a more stringent requirement to prove immigration status than the federal statute, we might well have a problem with preemption. as we've seen in some of the cases about SB 1070 and the sheriff's office sweeps. So, admittedly, that's not in the briefing. We didn't get that far with this, but if this were to turn on a distinction between the state and the federal requirements, the state being more stringent, that could be a problem. I should probably just spend a minute explaining why we're here. We're an intervener. The district is an intervener. We didn't participate in the proceedings below, certainly not as a party. But once the challenge was made by the hospital to its obligation to accept these individuals, that implicated the role and the responsibilities of the district, because the district serves as the agency to which the court sends individuals, number one, to be evaluated as to whether they need to be in the involuntary commitment process, and number two, at least in some cases, to provide temporary local treatment, which is a 25 or 30-day period before they would be transferred to the state hospital. Obviously, the district is a governmental body, and it is in the position, at least in some cases, of holding individuals who meet every requirement for treatment at the hospital, and there's no dispute that these two do. The only issue is about alienage. The district holds these people, or at least evaluates them, determines that they should be petitioned for commitment. What is the consequence to the district if the hospital is entitled to refuse to take them?
The hospital takes position in either in their reply, I think it was their reply, that ruling that PRORA prohibits this would not result in the release because they could be treated at other facilities. But that's something I'm having some struggle with, so maybe you can help me. Is if it's a benefit, public benefit for ASH to do it, it would be a public benefit for any state agency or even private company paid for by the state to do it, wouldn't it?
Exactly, and that's the role or the problem my client finds itself in. If there's a determination that ASH can't take these people for whatever reason due to their alienage, the same law and logic should preclude my client from having to deal with them as well. We're not trying to avoid that responsibility because we think ASH's legal argument is wrong. But any resolution of this needs to recognize the fact that the district as well, it's Desert Vista is the name of the facility, is in the same boat. We're not trying to avoid having to deal with these folks.
Counsel, given the conundrum that you found yourself in that required you to become an intervener, and the fact that it's two state agencies that are here that are basically involved, correct?
Well, the hospital is state, the district is county level, but same difference, it's public.
Here's my question for you. When you recognized that was there, was the AG asked for an opinion on this?
I don't believe so.
Okay, all right. It just seems to me like that would have been a lower level this could have been dealt with, and you would have had an opinion as to the application and the limitations, if you will, on what you could do.
Right.
Counsel, if the state's interpretation is correct, and I'm just thinking hypothetically, if the state's interpretation is correct, they cannot provide the mental health treatment. And I assume that being detained against your will is part of the dubious benefit that they receive. If they are not permitted to treat them, can they be held without treatment, without violating the federal or state statute?
That's an interesting question. I think, though, that the statute that applies to the state hospital requires that treatment. And so in order to comply with one statute, they need to be violating another. But that's a conundrum that, at least in our view, never needs to be reached, because the commitment process, in the first place, is not a benefit to the individual, which was intended to or which is barred by Ferwara or the state statute.
And given that it seems to be an unsolvable conundrum, doesn't that lend support for the interpretation that this isn't a public benefit?
I think it does, and I think it also points out the fact, and the court focused on this early on, and we'd like to come back to it here, which is, in order to reverse the trial court level decision, there has to have been reversible error. We don't see that the court made any reversible error. The hospital portrays itself as caught between a rock and a hard place, but the resolution of that is legislative, not judicial. And in fact, the federal statute specifically recognizes the authority of a state to pass a law that says this particular thing, even if it's a public benefit, is something we're going to permit to be provided to people regardless of their ability to show lawful presence. It's in the statute.
I'll invite Ms. Cochran to respond when she gets back up here, but what is the legal consequence to the state, to the hospital, if it provides a public benefit to these individuals in violation of a federal state statute?
There's nothing in either the federal or the state statute that provides a consequence, and we're not aware of any case authority, either state or federal, that says if you do provide services that you shouldn't be providing to somebody who can't demonstrate their legal presence, the consequence is A, B, C, and D. There just isn't.
So is undoubtedly a political problem for parties involved, but it's not a legal problem.
That's right, a political or an economic problem, but there's no legal consequence to it that we can find.
And as I understand, I think we're wrapping up here pretty quickly, but we have very limited options here. He can't be prosecuted and incarcerated. He's not able to defend himself. He's not willing to voluntarily agree to admission. And unless he's able to be involuntarily committed to ASH, then he's released. Isn't that fair? Is that your understanding? Is there an option we're missing is what I want to get to. Is there some interim thing that would take care of a public threat?
I'm not aware of any, and the reason for that is that these people are indigent by definition, so they can't pay for their own treatment. And I'm not aware of any ability of the court to, as an alternative to commitment to ASH, say, well, we're committing you to the private facility off in Wickenburg, and they're going to have to deal with you, and since the state can't pay for it, they're going to have to do it for free.
Or you're going to have to pay for it yourself.
Yeah, there's no alternative that we're aware of.
Okay.
If there,
With that, I think I'll just make my main point, which is simply there needs to be reversible error for this decision to be changed, and there wasn't. Thank you.
Thank you, counsel. Ms. Corcoran. And counsel, I apologize. I'm not trying to co-opt your rebuttal. We'll give you a little time, but can you answer my two questions? First is if receiving treatment is the public benefit, if the hospital is prohibited from providing that treatment because it would violate the federal and state statutes, can it simply hold the individuals apparently indefinitely? And then my second question is, if the hospital provides them treatment, what are the legal as opposed to any political or economic consequences to doing so?
Yes, Your Honor. So if treatment is a public benefit and the hospital is not permitted to lawfully treat these individuals because they cannot demonstrate their lawful presence in the United States, then the state hospital would not be able to hold them. The Superior Court, however, is required to consider all available and appropriate options. And to a point that was raised with intervener, nonprofit charitable organizations are not required to comply with Peror's eligibility verification requirements.
That's the first time I've heard that interjected in there. Non-profits would have to take them and hold them in a security facility.
They are able to take them because they are not required to comply with Peror's eligibility verification requirements, and that is in the supplemental authority that intervener provided. However, additionally, when someone is committed to a hospital, and this is not in the briefing, so this would be supplemental authority, ICE is prohibited from detaining the individual. When they are no longer under a court order, ICE can indeed detain the individual, and that's at 8 CFR section 236.2b.
And isn't that because at the time that they're no longer in an involuntary hold, that they're deemed capable of being pursued by ICE? You understand what I'm saying? Once they reach a minimum level of being able to take care of their own interests, I suppose I would say.
No, Your Honor, that's not the case, because also under federal regulation, it makes clear that someone who is not competent can nonetheless be a deportation order can nonetheless be sought for the individual. That is also in the federal regulations. I can certainly supplement the record if you would like that.
It's a new theory to me. Thank you.
In terms of the penalties, there are penalties within 1502 itself for violating 1502. That's at subsection E, G, and H. In addition, there are penalties for inappropriate expenditure of state funds, and the Texas Attorney General has considered this and explained that providing services in violation of PERORA could trigger penalties in other federal laws as well. Additionally,
providing benefits of this type? Was it a mental health?
It was a
involuntary commitment, they said, in that circumstance?
The particular question to the Texas Attorney General was about health treatment at a hospital district, but there was a general statement that providing benefits could lead to other penalties in federal law.
So let's get back to the main point. I think the main argument, we'll all assume, and I'm not saying we've decided this, but that the logic relied on by the trial court was flawed. So the question then that we have to resolve is this a public benefit? You'd agree with that, right?
Yes, Your Honor.
Okay. So, and there is no authority you cited or they've cited that really resolves the issue in the context that we've got here of this involuntary commitment, whether it's a public benefit.
Well, actually, Your Honor, I think there is, because the legislature has
assumed that there isn't, because the authority that's cited in the briefs, and I've reviewed it, does not resolve this specific issue. So you don't have to agree with me. I'm just laying that foundation for the question. So we'll get to the second question, which is, if we adopt the interpretation that you're urging, it seems that we'd have a problem with prisoners, because prisoners are provided health care and mental health. And you argue, no, that isn't, mental health benefits aren't public benefits in that case, right? That's your argument?
Yes.
Okay. And I think you said earlier it's because you look at whether it's incidental, that's what makes the distinction, whether it's incidental to confinement or the purpose of confinement, right?
It is also the intent of Perora, which was to not burden the public benefit system, and incarceration is not a public benefit system.
But where's your authority in Perora that says incarceration is not a public benefit system?
Off the top of my head, I cannot.
Because there isn't. So is there authority that says civil commitment is a public benefit system? If you're saying it doesn't say incarceration is civil commitment a public benefit system?
Well, the closest thing asserting that is In re DG, which there
North
was.
Carolina case, right?
Yes, it was the North Carolina case.
Moving on. Next, you're adopting this incidental versus not incidental distinction, right? Because it's not involuntary versus voluntary, because then we'd have prison and civil commitment would be the same, correct?
It's not only incidental versus non-incidental. It's also the intent and purpose behind the provision of the.
That's what incidental means. Either it's the purpose is this, or it's an incidental to it, right?
Yes.
Okay. So if it's that incidental versus non-incidental, what about other types of benefits provided in prison? So let's say it's not the mental health treatment, it's not the medical care or food that they're provided. What about drug and alcohol treatment, which is a voluntary thing that public has determined is a benefit to society as a large to try and provide drug treatment to prisoners? Would that be something that would be prohibited?
Your Honor, I do not believe that any incidental, as you're defining it, benefit that accrues to an individual who's imprisoned is actually a public benefit.
So if, I'm sorry.
And I can provide a basis for that.
Okay, help me. Because I'm so confused by this, and I don't mean to sound dismissive, but I'm not seeing the distinction that you seem to think is very clear, and I feel like I'm missing something.
A public benefit is something that someone applies for. Incarceration is not something that anyone applies for.
So did Edgar or Juan apply for the public benefits of involuntary commitment?
Someone applied on their behalf.
Who?
For the physicians who petitioned for the commitment, applied on their behalf for them to receive public benefits. And I will point out that the Arizona legislature has considered this as a possibility, because at ARS 1502C, they require individuals with mental incapacity to nonetheless provide documentation when they are applying for public benefits. Now, if someone is mentally incapacitated, they necessarily need to have someone apply on their behalf.
But
that
no
was the
one's applied
situation
for
here.
anything on their behalf. It has been ordered on their behalf. No one has applied for anything on their behalf.
Well, it has been ordered because they are unable to apply on their own, because they are unable or unwilling to seek treatment.
Counsel, isn't that circular? They couldn't do it on their own, so someone else did it for them, so now they don't get the benefit they were applying for?
No, they do get the benefit. The fact that someone else is applying on their behalf means that they are applying for that benefit.
So the fact that the benefit has been applied, as you say, applied on their behalf, that implies that Ash or the hospital could say, for whatever reason, we deny your application. I don't think if the court orders commitment occurs. Correct? I mean, to apply for a benefit implies that the agency giving the benefit can deny the benefit.
Well, they can deny the benefit when an individual is unable to demonstrate their lawful presence, which was the situation here. Although there is not a finding, and that is what we're asking this court to remand for, is a finding as to whether or not these individuals can demonstrate their lawful presence in the United States.
And so we kept you way too long, but I've
got one more time.
Sure. If you have a person who is who can't prove that he's lawfully present is convicted of a crime, is sentenced, and the sentence is suspended and is placed in probation, and as a condition, as a term of the probation, must receive mental health treatment. How that seems awfully close to providing a public benefit, because they're not incarcerated. The treatment that they've been ordered to receive is really that punishment is assistance to that individual. So how do you distinguish that?
Because you're still operating within the criminal system. So if that individual does not comply with the probation requirements, they can be reincarcerated. So it is still for a criminal purpose at that point.
But the treatment is in no way punishment, right? Correct? The treatment that is ordered pursuant to an order setting up probation, that's not punishment, right?
It is nonetheless associated with the criminal conviction, and therefore it is associated to the punishment that the person received.
What about job training during prison sentences? It's not part of the punishment. It's something that they apply for even. They ask to be put into job training programs while they're in prison. Would that mean that's a public benefit that we can't offer to prisoners who can't prove lawful status?
No, because again, you have to look at the purpose behind where the individual is. So the purpose behind the criminal conviction is punishment, and the intent and purpose of Perora is to not burden the public health system.
I'm talking about things we offer to prisoners to help them not be recidivists when they come back. So we offer job training, we offer drug treatment. These are voluntary. They're not usually as a condition. It's not something they have to do in order to be released from prison. So how is that different?
Because I believe this requires a factual determination that is not in the record. However, it would be my understanding that the services that are provided within a prison are not part of the general public benefit system. And the purpose behind Perora is to prevent a burden to the general public benefit system. Here,
you would not ask us. You would say, but ASH is part of the general public benefit. Anyone can go walk up to ASH and self-check themselves in.
In statute, that is a possibility. Again, not in the record. Currently, the hospital treats people who are committed. However, statute does allow people to voluntarily commit themselves to the state hospital.
Scratch to say this is something generally available to the public at large.
It is available. I believe it is available to the public at large. If someone is in need, there's a mental health benefit system within Arizona. And if someone is in need of a mental health benefit, that is available on a case-by-case basis to the general population. So for that reason, it is a public benefit. And when you have individuals who are committed to the state hospital, who cannot demonstrate their lawful presence in the United States, what that ultimately means is that there are other individuals who are eligible for those services, who are unable to receive those services because those beds are being taken up by individuals who are not eligible to receive those services. And for that reason, or that is another explanation as to why this is a public benefit, because it fits into that intent and purpose of not burdening the public benefit system. And additionally, the legislature certainly can act here. So under 8 U.S.C. 1621D, the legislature can allow individuals who would not otherwise be eligible for mental health benefits to receive them. The legislature has not acted here to affirmatively allow otherwise ineligible individuals to receive public benefits. And combined with that, in ARS 1502C, they have explicitly considered individuals who are mentally incapacitated and nonetheless require them to provide documentation that they are lawfully present in order to receive mental health benefits. So
the legislature has addressed this in some form of a conclusion and passage of some bill?
no, the legislature is able to address this and has chosen not to do so.
Chosen not, or hasn't been approached about it?
There is no law that has been enacted that affirmatively allows individuals who would otherwise be ineligible for public benefits to receive them. Under 8 U.S.C. 1621D, the legislature is certainly able to enact such a law, and I think the companion is ARS 1502C, which ties into PERORA and explicitly considers individuals who have a mental incapacity. So the legislature has considered these individuals.
Counsel, we appreciate your willingness to answer our questions way past your time.
You have great stamina,
if I may,
Counsel.
On reconsideration, I would like to point out exactly what relief we are asking here, because I think it was vague in the briefing. So if I may just end with that. We would ask that the court hold that non-emergency mental health treatment is a public benefit, reverse the Superior Court's ruling that mental health treatment is generally exempted from PERORA's eligibility verification requirements, reverse the Superior Court's finding that mental health treatment at the hospital meets the three-pronged test set forth in 8 U.S.C. 1621b4, and remand the case to the Superior Court for findings as to whether or not Juan A. and Edgar T. can demonstrate their lawful presence in the United States.
Thank you,
Thank you.
Counsel.
Thanks, Counsel.
Thank you.
We appreciate your arguments today. We'll take this matter under advisement and will issue a decision in due course. We stand adjourned. Thank you.